My name's Alison Fleming. I'm a lawyer within Langate. I've been working on these reforms since 2014. It's a long time. But we're really looking forward to be able to be proclaiming the legislation fairly soon. Just hands up those who are actually new to the sessions. So who hasn't been here for the other sessions? So there are a couple of you who I could perhaps run through a brief couple of slides. So this afternoon we're going to be looking at leasehold strata. What is it? How's the Act changing to deal with it? And what to look for in a leasehold scheme, among other things. I'll be talking to you for about 40 minutes. There'll be about 20 minutes for questions afterwards, including how to find out more and have your say. We'll start off with the disclaimer. Obviously, whatever I say today, we've taken all care in telling you, but obviously there's nothing like having a good read of the Act and the proposed regulations. So there it is. That's how it will be amended. It's available on our strata.wa.gov.au website if you go into the document library. The draft regulations are also there in the document library. Nothing like a good read. So as has been mentioned previously, the Strata Titles Act 1985 has been substantially amended by the Strata Titles Amendment Act 2018. You really don't want to read that. It's not a nice read at all. It says, delete clause such and such, insert such and such. Insert the whole of a section 183, I think it was, 182, 183, that had complete new parts of the legislation. Definitely don't want to read that. What you do want to read is on our website, which is the amended Act, how it will be when it's proclaimed. The Community Titles Act 2018 is a completely new act as well. That's going to introduce community titles into WA. As mentioned previously, we're not talking about that today, but I will touch on it in a couple of areas. So one of my colleagues touched on the difference between the Act and the regulations. The Act basically sets out the Act sets out what you need to comply with, and the regulations describe how to comply. If I can give you an example, where are we? So section 52(1), for instance, of the amended Act provides that a strata lease can only contain covenants or conditions contained in the regulations. So that's saying to you, I need to go to the draft regulations to see what the standard terms and conditions are going to be. That's an example of how the regulations set out what you need to do. So we're particularly needing your feedback on the consultation draft regulations, and later on in the presentation I'll be drawing your attention specifically to areas of the regulations relating to leasehold strata. If I can just go back in history a little time, the Community Titles Advisory Committee, which was set up by a Minister for Lands in 1997, had as one of the items on its agenda leasehold strata. Leasehold strata does exist in other jurisdictions and other countries. For example, British Columbia, Singapore, New South Wales, the United Kingdom. We've looked at all of those and come up with our own unique model. As mentioned previously, the timeline for reforms. So for those that haven't been here previously, September is our month for public consultation. We've done a number of regional presentations, and we've done a number of metro presentations. It's culminating in this session today. After these sessions, we will be taking on board all the feedback that you give us and delivering final regulations through the Gazette and then on through Parliament. And so at the end of the day, we will be proclaiming the amendments that are contained in the Strata Titles Act, Amendment Act 2018, which will then mean that the amendments take effect in the Strata Titles Act 1985. A little bit confusing, but we will still have a Strata Titles Act 1985. So we're looking now at introducing leasehold schemes. A separate act was considered for leasehold schemes. New South Wales actually recently merged their leasehold schemes back into their strata legislation. One of the reasons for not having a separate act is that over time the two become separate. And in the case of leasehold schemes, many of the provisions are the same for leasehold schemes and survey strata schemes that you already know about. So it was decided that we would actually put the leasehold strata into the Strata Titles Act 1985. One of the things that won't be happening in the Community Titles Act is leasehold strata. We have not built leasehold strata schemes into the community titles legislation. So what will leasehold schemes do? The strata reforms will introduce a new form of subdivision of freehold land in WA, and my emphasis here is on freehold land in WA, to create a leasehold scheme. The scheme may be leasehold strata or survey strata, but you can't mix leasehold lots with strata lots or leasehold lots with survey strata lots. So you can't have a mixed scheme. Leasehold schemes have an extra scheme document. I think, as my colleague mentioned this morning, new schemes will have a number of scheme documents: a scheme notice, bylaws, schedule of unit entitlement, and plan. Leasehold schemes also have a strata lease for each lot. Opportunities afforded by leasehold schemes. Well, we think the marketplace is going to determine how much leasehold schemes are used. It offers a new form of subdivision and land tenure option in the WA marketplace. There's potential for more affordable housing, and leasehold strata can be used for freehold land which can't be sold, and land that is being held strategically for future uses. So, for example, one of the examples that we've thought of is, say, the development of a shopping centre near a new Metronet station out in the far suburbs. There, it may be possible to create a leasehold scheme, a commercial scheme, for the shop owners to own for a period of, say, 20 years, so that the so that the density can then work towards the shopping centre. We will see what happens. Another example has been given as universities or churches who may have a restriction on their ability to sell the land, but nevertheless want to use the land to earn a commercial return. It may be possible to leasehold strata the land for that purpose. Local government rates and land tax liability will be strictly addressed. What that means is that the owners of leasehold lots will be responsible for the local government rates and land tax liability. And a leasehold strata certificate of title will be issued, which should simplify financing for the purposes of obtaining mortgages. So what is a leasehold strata title? Well, it's the title to the land comprised in a lot in a leasehold scheme. It comes into existence on registration of the leasehold scheme. A certificate of title is created and registered for each leasehold strata title under the Transfer of Land Act, 1893. For those of you that are purists, there has been a change in the legislation there because it was never really clear whether the certificates of title were being issued under the Strata Titles Act or under the Transfer of Land Act. The legislation now clearly specifies that the certificates of title are created and registered under the Transfer of Land Act 1893. The owner of a lot in a leasehold scheme has a strata leasehold estate in the lot. Compare that to a fee simple interest in the lot if you are a strata owner or survey strata owner in a freehold scheme. You also have an undivided share of the strata leasehold estate in any common property as tenant in common with the other owners of lots. Contrast that again with the freehold scheme where you have an undivided share in the fee simple in any common property as tenant in common. So what will be changing? How is the Act being changed to accommodate leasehold strata? By the way, you don't need to be taking all these photographs. The slides will be being made available to you on our website, along with the video recordings. So, how have we dealt with leasehold strata in the Act? Well, we've got a lot of new definitions included. So, for example, I won't touch on the owner of a lot because that's coming later. But at least we have drawn a distinction between what a leasehold scheme is and what a freehold scheme is. So a freehold scheme is a strata title scheme. Each lot in the scheme is a freehold lot. There's no separate title for the parcel subdivided by the scheme. And the parcel can't be dealt with, including by registration of a mortgage, or disposed of under the Transfer of Land Act 1893. No change as far as strata and survey strata is concerned. But for a leasehold scheme, it's a strata title scheme in which each lot is a leasehold lot, subject to a strata lease. A certificate of title for each lot is issued. The scheme and each lot in the scheme expires on a specified day, the expiry day for the scheme. And there's a separate title for the parcel subdivided by the scheme. The registered proprietor of the parcel, the owner of the leasehold scheme, is entitled to the reversion in the land on the expiry or termination of the scheme. A strata lease is the lease registered or proposed to be registered for the lot as a scheme document. Those are just a couple of the definitions. If we then look at new provisions in the Act, there are some provisions that are specific to leasehold schemes. And I've mentioned 3 in particular. So we have Part 4, Division 5, which specifically deals with strata leases. Part 5, Division 2, which specifically deals with re-entry or surrender of strata leases. And surrender there isn't your normal surrender. What that means is that the owner of the lot is giving the lot back for whatever reason to the owner of the leasehold scheme, but the lease doesn't disappear at that point. The strata lease stays in existence, and the owner of the leasehold scheme becomes the owner of the lot as well as the owner of the leasehold scheme. This is to ensure that all the strata leases for the lots keep on rolling until the expiry of the scheme. And then we have Part 12, Division 2, which is expiry of the leasehold scheme. I'll deal with that in a little more detail later on. So then we have some new provisions in the Act that are tailored specifically for leasehold schemes. The example I've given is in relation to the strata company entering into transactions in respect of the common property. A strata company may enter into a transaction to which the section applies as if for a leasehold scheme it were the owner of a leasehold estate in the land under a registered lease that expires on the expiry day for the scheme. Contrast that with section 93(1)(a), which says if it's a freehold scheme, then the strata company can deal with the land as if it were the fee simple owner. So leasehold strata versus freehold strata. A freehold strata survey strata scheme can exist indefinitely, although the Strata Titles Act does provide for termination of the scheme. Living in a leasehold scheme will be very similar to living in a freehold scheme, except the scheme will have a fixed lifespan with an expiry date. There will be strata meetings. Leasehold lot owners are the strata company, and the lot owners will pay contributions in proportion to their unit entitlement, unless varied in the scheme bylaws, in exactly the same way as owners of lots in a freehold scheme. The owner of the leasehold scheme will have a limited role in the day-to-day running of the scheme. Contrast that with the responsibilities of the lessor under a normal lease. Unlike a survey strata scheme, where the certificate of title for the parcel is cancelled on registration of the strata scheme, there will continue to be a certificate of title for the parcel, and the owner of the leasehold scheme will have the reversionary interest in the parcel. So the owner of the leasehold scheme, subject to any restrictions on disposal that it has, will be able to sell the reversionary interest or mortgage the reversionary interest, but it won't be able to partition the reversionary interest, and it won't be able to do other things that you could ordinarily do with a certificate of title. The scheme will have governance and conduct bylaws. They may be the scheme bylaws in Schedule 1 and governance and conduct bylaws, or they could be a complete set of new bylaws. So what are the particular features of a leasehold scheme? Every lot will have a certificate of title. No duplicate certificates of title will be issued by the Registrar of Titles. No certificate of title will be created for the common property in a leasehold scheme. That's exactly the same as for a freehold scheme. The reason for that is the owner has the proportionate share in the common property reflected in their own certificate of title for the lot. The term of the leasehold scheme and strata leases must be at least 20 years and not more than 99 years. You can't dispose of the strata lease separately from the title to the lot. Every strata lease in the scheme expires at the same time. The strata leases, the plan, and the titles are all tied to one another. So a leasehold scheme can be either strata or survey strata. They can only be created over freehold land or conditional tenure land. Conditional tenure land is land transferred from the Crown under Section 75 of the Land Administration Act, 1998, subject to conditions concerning the use of that land. So we have not extended leasehold schemes to Crown land. The same person can be the lessor and lessee of a leasehold lot. Valuation and unit entitlement provisions will apply in the same way as for strata and survey strata. And when you're transferring a leasehold lot, that will be dutiable. Because what we've tried to do is make leasehold strata lots as close to freehold as we can. Simply because you're paying a premium up front for the lot, and therefore it would be unreasonable to expect that your normal provisions around forfeiture and the like of leases would apply in the scenario where you've paid for what is essentially a fixed term for the lot. So who is the owner of a lot in the leasehold scheme? Also known as the lessee. So the owner of a lot in a leasehold scheme is the person who is the lessee under the strata lease. They're able to undertake the following without the lessor's consent. They can transfer the leasehold strata lot. You can mortgage it. You can sublet the leasehold strata lot, except where the parcel is conditional tenure land. In that case, you do need to get the consent of the owner of the leasehold scheme. Simply because the owner of the leasehold scheme is subject to whatever the restrictions were in connection with the grant of the conditional tenure. The owners of lots in a leasehold scheme are members of the strata company and decide how to run the leasehold scheme subject to the Act and the scheme bylaws. Owners will be liable for rates and taxes in the same way as for freehold lots. The owner of the leasehold scheme, also known as the lessor under the strata lease. The lessor will be involved in providing approval to the owner of the lot if the owner of the lot wants to carry out any structural alterations, erections, or extensions on the lot. Remember that you already have those obligations to obtain the consent of the strata company when you're doing lot alterations and extensions. What we're saying here is you also will need to get the consent of the owner of the leasehold scheme in that scenario. We're also saying that when you want to amend your scheme plan in any way, for example, by bringing land in, taking land out, consolidating, re-subdividing, then you will need the consent of the owner of the leasehold scheme to do that. for the simple reason that the owner of the leasehold scheme has the reversion in the underlying parcel of land. So you're actually dealing with the underlying parcel when you're doing a scheme plan amendment. The lessor will not be involved in the day-to-day management of the leasehold scheme, generally will not be required to consent to the transfer of the leasehold strata lots. Consent will be required from the owner of the leasehold scheme in connection with a sublease where the land is conditional tenure land. And the consent of the owner of the leasehold scheme will also be required where you're making leasehold bylaws or staged subdivision bylaws. I'll be going into leasehold bylaws in a little more detail a bit later. So things to know about a strata lease. When registered, a strata lease is taken to be a registered lease under the Transfer of Land Act. But provisions in the Transfer of Land Act and the Property Law Act that would ordinarily apply to a lease don't apply. This is to ensure that a strata lease is treated as far as possible like freehold land. The provisions of the Commercial Tenancy Retail Shops Agreement Act also do not apply to strata leases. The owner of the leasehold scheme cannot re-enter a lot except if authorised by the tribunal or under the leasehold bylaws for non-payment of an amount for postponement of the expiry day, or if the owner of the lot surrenders the strata lease. A strata lease must be in an approved form and can only contain covenants or conditions allowed by the regulations. As I just mentioned previously, the buyer of a strata lease pays an upfront capital payment. The covenants and conditions of the strata lease that we're proposing in the regulations include a provision that you cannot include payment of rent as a covenant or condition. A strata lease must identify as a fundamental covenant or condition a breach of condition that may lead to an order for re-entry by the tribunal. The regulations identify conditions that are fundamental. One of these is that you are in breach of the Act. That's considered to be a fundamental breach. The owner must ensure that mortgages and caveats are discharged, removed on expiry termination of the leasehold scheme. It's the owner's duty in the covenants and conditions to maintain the lot, but that's limited. Fair wear and tear and other unforeseen events are excluded. If the leasehold scheme is on conditional tenure land, compliance with the conditions imposed on the parcel under section 75 bracket 3 capital B close bracket of the Land Administration Act is also considered a fundamental covenant or condition. The regulations are going to form a very important part of the leasehold strata regime, and therefore it's quite important that you do have a good look at what the regulations are proposing, particularly in relation to strata leases and the covenants and conditions that apply to those. Scheme bylaws will be invalid to the extent that they are inconsistent with the covenants and conditions of a strata lease over a lot in the scheme. If the regulations are amended to change the standard covenants and conditions of strata leases, an owner of an existing strata lease can agree with the owner of the leasehold scheme to vary the covenants and conditions in their strata lease to bring it into line with the most recent covenants and conditions. But that's pretty much the only variation that will be permitted. Enforcing a strata lease. The owner of the leasehold scheme or an owner can apply to the State Administrative Tribunal for enforcement of a covenant or condition in the strata lease or an obligation under provisions of the Act relating to strata leases. The owner of the leasehold scheme can't apply to the tribunal before giving notice of the breach to the owner of the lot and any mortgagee of the lot, and allowing a reasonable time for remedy of the breach and/or reasonable compensation for the breach. The tribunal can make a number of orders, including that the owner of the lot do or refrain from doing a specified act, payment of compensation to the owner of the leasehold scheme, or vesting the strata lease in the mortgagee. It's only if the breach is a fundamental covenant or condition and the tribunal is satisfied that the owner of the leasehold scheme cannot be reasonably compensated, the tribunal may authorize the owner of the leasehold scheme to re-enter the lot. So what are the leasehold bylaws that I mentioned? The leasehold bylaws enable a leasehold scheme, the expiry day for a leasehold scheme, to be postponed. If you haven't got leasehold bylaws, then you can't postpone the expiry day for the scheme. Remember that your scheme will expire on an expiry day that will be specified, and it will be specified in your scheme notice. It can't be postponed if the scheme doesn't have leasehold bylaws. So leasehold bylaws provide for essentially two things: postponement of the expiry day for the scheme and compensation payable on expiry of the scheme. The expiry day can't be postponed to a day more than 99 years after registration of the scheme. So say your scheme was for 30 years originally, okay, you might extend that for 69 years, but that's the maximum. That's the maximum. The scheme expires at that point. In order to bring in leasehold bylaws, they're classified as governance bylaws under the amended Act. They will require the approval of the Planning Commission in order to make them, and they will also obviously involve the consent of the owner of the leasehold scheme. Once you have got your leasehold bylaws in place, then a resolution in favour by owner of 75% of the lots is required to postpone the expiry day. So your postponement of the expiry date must be indicated in the leasehold bylaws, and it requires a 75% of the lots to actually do the postponement. And that resolution must be passed not later than 6 months before the expiry day for the scheme. As soon as practicable, after passing the resolution to extend the expiry day, the strata company must serve notice on the owner of the leasehold scheme in an approved form and apply for registration of an amendment of the scheme notice to give effect to the postponement of the expiry day. I mentioned compensation. There are two types of compensation that leasehold bylaws may provide for. The first is an amount payable by each owner of a lot if the owner of the leasehold scheme has agreed to postpone the expiry day. The second is compensation payable to the owner of a lot by the owner of the leasehold scheme on expiry of the scheme, and that's in respect of improvements to the lot effected by the owner of the lot or a former owner. The current draft regulations have not provided for compensation, whether that be paid by the owners of lots or the other way around, the owner of the leasehold scheme to lot owners. That might be something that you would wish to comment upon. Compensation payable by each lot owner must be in proportion to the unit entitlement of their lot, and the bylaws must set out how the amount is to be calculated, when and how each amount is to be paid, which is at least 4 months before the expiry day, and provide that if the amount is not paid as required, the owner of the leasehold scheme is entitled to re-enter the lot from the end of the expiry day for the scheme that applied before postponement. Those provisions are set out in the Act. So when we get close to the scheme expiry day, owners of the leasehold scheme must ensure that the notice is lodged with the Registrar of Titles of the impending expiry at least 1 month before the expiry day, and no earlier than 3 months before the expiry day. There's an offence punishable by a fine of up to $3,000 not to notify the Registrar of Titles or owners and occupiers. Then there's another notice. Owner of the leasehold scheme must ensure that notice of expiry is lodged with the Registrar of Titles at least 14 days before expiry of the leasehold scheme, and after the notice of impending expiry is lodged with the registrar. It's an offence punishable by a fine of up to $3,000 not to notify the Registrar of Titles of expiry of the scheme. So the effect of expiry of a leasehold scheme. The leasehold scheme is terminated at the end of the expiry day for the scheme. The Registrar of Titles cancels registration of the scheme and the certificates of title for the leasehold strata lots. The owner of the leasehold scheme becomes the owner of the parcel and is entitled to vacant possession of the land. If the leasehold bylaws provide for compensation payable to owners of lots for improvements, the owner of the leasehold scheme is liable to make the payments. From that point on, the owner of the parcel could enter into leases, normal leases under the Transfer of Land Act, with previous tenants or previous owners, but would not be obliged to do so. That would be just one of the things that the owner of the parcel could do at that point. So looking more closely at the proposed regulations that we're specifically encouraging you to go and have a look at, Part 9, Strata Leases. The provisions are to the effect of Division 1 and 2 in Schedule 3. The covenants and conditions of strata leases are quite limited. And again, this reflects the fact that we're trying to make leasehold strata and survey strata as close as possible to freehold without actually calling them fixed-term freehold. One of the things that I strongly encourage you to think about is that these are not normal leases. They are purely statutory creations, and the powers and functions of them are set out in the Strata Titles Act. So a strata lease may not provide for certain matters referred to in the regulations. I mentioned payment of rent was one of those things. There are situations under the regulations where the lessor's consent is required to deal with the leasehold strata title, in particular where it's the subject of a conditional tenure. Amendments of the strata lease, the only amendments allowed are to opt into the current standard covenants and conditions in the regulations. So the Act basically says that the only covenants and conditions that you can have in a strata lease are set out in the regulations. So essentially the only amendment that you can have is an amendment to bring into force in your lot the current set of standard conditions that are set out in the regulations. Part 16, miscellaneous, notices of expiry, and then Schedule 3, Division 1 and 2, which are the standard terms and conditions and covenants and conditions for strata leases. So they are available on our website in the document library. Please go and have a look at them. To view and comment, please go to strata.wa.gov.au. And then, as my colleague mentioned earlier today, if you want help on how to read the legislation, go to the website here first, department.justice.wa.gov.au, which sets out guidelines on how to read legislation. You can subscribe for updates on the key developments, and obviously keep in touch with how the reforms are progressing by subscribing on our website. You'll be able to share and watch this session again, for those of you that are keen to do so. Or if you want to let other people know about the information about leasehold strata.